Hello friends, in the series on income tax cases, today we will discuss a case in which a very pertinent issue was before Delhi ITAT SMC bench, and the issue was that if the assessee is in some business which is unorganized, the nature of the business is such that the assessee has to receive the payment in cash and have to make the payment for the expenses mostly in cash, and the assessee has died and the assessee's son is not in a position to give the sufficient evidence, and the assessee's son also suggests that he is not able to continue the litigation for a very long time because of the limited means. So whether in that case the nature of the business should be considered to make the addition in the hands of the assessee. This issue has been taken up by Delhi ITAT SMC bench in the case of Rahul versus Income Tax Officer, and this case is reported in 135 ITR Tribunal at page number 16, and the date of the judgment is 2nd December 2025. In the present case, the assessment year is 1718, which is a demonetization period. The assessee was in the business of brick kiln, that is making of the bricks. An amount of rupees 45 lakh was deposited into the bank account during the year. The case was selected for scrutiny, and the assessing officer made the whole amount of cash deposited into the income of the assessee under section 69A by applying the rate of 60% under section 115 BBA. The assessee was not well. The assessee was also going through the period of COVID, so due to which there was a delay of 707 days in filing the appeal before the learned CIT appeal. The CIT appeal didn't allow the condonation and rejected the appeal of the assessee. The assessee preferred a appeal before the tribunal through his son and the legal heir, and the assessee pleaded that the delay in filing the return was due to his father's illness and due to the COVID-19 period. The assessee's son also pleaded before the tribunal that the son do not have much evidence and means to contest the long drawn process of litigation. The son also pleaded before the tribunal that the business in which his father was there was a business of unorganized sector of making the bricks, and mostly the sales was made in cash, and the expenses constitute majorly of the labor expenses and of procuring the soil from various persons where the payment into cash is to be made. When the tribunal heard the matter, the tribunal said that in the present case the assessee do not have much evidence, but the nature of the business of the assessee is such that the assessee has to receive the payment in cash, and there is no denying the fact that the assessee was in the business of brick making. The assessee suggested a rate of 8% for making the addition, for which the tribunal agreed at the rate of 10%. At the same time, the tribunal said that the entire cash deposited into the bank account of the assessee cannot be treated as income, and the tribunal said that in the present case even the special rate under section 115 BBE cannot be applied because the income is not in the nature of unexplained income. The income is in the nature of business income, which has been explained very well by the son of the assessee. Friends, this case is very important because the arbitrary addition of 45 lakh was made under section 69A even without going into the nature of the business. Even the best judgment assessment should be made in the light of previous assessments, in the light of whatever the material is on hand. Sometimes it happens that the assessee do not receive the notices, or sometimes he is not able to give the reply also. So even the best judgment assessment should be made with a sense that only the real income should be taxed and the arbitrary addition should not be made. If we compare the case, the assessing officer made the addition of 45 lakh applying the rate of 60%, and the tribunal reduced that addition up to 4.5 lakh, and that too as normal business income and not applying the special rates under section 115 BBA. Friends, this case is very important as far as understanding the concept that the nature of the business plays a very vital role in determining the assessment of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Rahul versus Income Tax Officer, and this case is reported in 135 ITR Tribunal at page number 16, and the date of the judgment is 2nd December 2025. Thank you, friends.